Well, good morning. Welcome to the April 25, 2025 Alabama chapter of ASSP meeting. Oh, yeah. Gotta reset it, I guess. If you would, please stand and join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic which stands one nation under God, indivisible, with liberty and justice for all. Randy, would you lead us in a prayer this morning?
We also ask you to bless our employees, our companies, to help us to fulfill our mission and that of ASSP and a profession to preserve people's lives and health and well. Thank you for the provider. We thank you for this session. We ask you to bless Jeff as a leader. We thank you for this day and for everything in your precious name.
Amen. Thank you. Today we have a great opportunity of Jeff Rogers, who's president of AGC Alabama, and he's going to do a presentation today on DEFCON, was it 25 nuclear verdicts? Actually, it's DEFCON 1 nuclear verdicts. Jeff, it's all yours.
Thank you. So thank you for having me today. It's an honor to speak with you all. Randy has had the unfortunate experience of hearing this once before. But before I start, I'm going to ask a question. Those in the room and those online, I know those online really can't raise their hand, but raise your hand if you've seen or heard some type of ad from a lawyer saying he or she will win you $1 million or more, either on the TV, radio, billboard, or social media since you woke up this morning.
Call me, Alabama.
Yes. I know a lot about him. I grew up with that family, and I can tell you more than you. Very interesting story. We're going to touch on that a little bit here today. The ironic part was we were tied up against them on a nuclear case, and I kid you not, about 2 nights before we offered the same presentation at our construction risk event, that digital billboard, he had his picture on there for construction cases. So, and it's not coincidence, but my name is Jeff Rogers. I'm with the service company of Alabama AGC. I've been intrigued by nuclear cases for quite some time. I started off working in operations for a high-risk specialty contractor in the mid-1990s. I was an operations manager. I worked with a crane rental and rigging division. We did have an industrial construction division. I was kind of the go-between our safety staff and management and the field labor. And so whenever there was an incident, I was always in the center, in the middle. I sat in mediations. But what I noticed is the legal environment today is much different than it is now. Part of that by design. And it's kind of how AGC formed its Workers' Compensation Fund. So I worked for the specialty contractor. My last 3 years there, I recognized how much insurance impacted business. What they told us we could do, couldn't do, not a whole lot of it made sense. Some of it was contradictory to what our risk management or safety staff was promoting. And I saw that very few insurance underwriters really understood industry and construction, and that if somebody knew a little bit about that side, they could probably have a pretty good career in insurance. So I moved over to the insurance side, working with solely the construction industry. I did that for about 8 years prior to coming on staff at AGC. Came to staff on AGC in 2012. In 2015, they moved me to the for-profit side of AGC. We were in the middle of revamping that side. So that side is responsible for, we provide workers' compensation to about 350 construction companies in the state of Alabama. In 2017, we created a property and casualty insurance facility that writes general liability, auto, property, inland marine. As a group self-insurance fund, we're one of the few in the country and the only in the state that is rated by the International Rating Agency that rates insurance companies. They require us to do an enterprise risk management plan, and that concept was a little foreign to us back in 2012, 2015. They kept sitting it back. It's been a wonderful blessing because it makes us better. But one of the things we identified in that enterprise risk management plan that one of the greatest threats to our insurance operations was a hard shift in the tort system. So I began monitoring and doing research when we had to finalize that around 2016, 2017. The whole reason the Alabama AGC Workers' Compensation Fund is even in existence was because at one time in the early 1980s, it was almost impossible for a construction company to procure workers' compensation insurance in Alabama because of the litigious environment we were operating in. And it wasn't just construction, it was all industry. In the 90s, there were, in early 2000s, there were two administrations that really shifted to pro-business, put some rules and laws in place to try to level out the playing field. But I can tell you we are seeing down. Okay. We're seeing a hard shift. If you've ever been on a roller coaster like this, you know what it's like going up. You hear that click, 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 click. You can feel it. There's the anticipation. And then it tends to slow right before you get to the top, and then gravity takes over and you're on the ride of your life. That's where we are as a country and a state in the current legal environment for industry and business. Did it again. So I'm going to give you a little background. And most of you can appreciate and remember this time period. It was the Friday before Thanksgiving of 2021. It was 3:30 in the afternoon. I'm sorry, 2020. If you remember what was going on during that time period, we're in the middle of the pandemic. In Alabama, the infection numbers were just starting to skyrocket. AGC, we fought hard and lobbied hard to keep construction deemed essential because Alabama was one of the last states to feel the effects of the recession in construction. But we were the second to last state to recover. The construction industry really was just starting to hit its stride in late 2018, 2019, then the pandemic hits. Our industry in our state had there was a backlog of work to be performed that could easily be shut off out of fear. So we pushed hard. We really worked hard to better educate our members because we knew there were some high-profile projects going on in the state, one in Tuscaloosa that did get bad publicity, one in Birmingham that got good publicity, that if the public did not see our members' employees doing what they needed to do to be able to work safely on the job, our industry would get shut down. So we lobbied hard. We had a member that was a general contractor that was hired by one of the largest world's defense contractors to build a facility in rural Alabama. It's a facility that builds weapon systems. If you recall, during that time period, that fall of 2020, October and early November were extremely rainy. Also during that time period, it was extremely hard to find labor, skilled labor, trained labor, because people were getting paid to stay at home. And we're going to kind of touch on that point a little bit later. The reason I bring all that up is the general contractor had two subcontractors working on the roof, and because of the weather delays, they were trying to play catch up right before the Thanksgiving holiday. But this particular defense contractor, extremely hard to get in on the facility. You have to go through all kinds of clearances, so it made finding labor even harder. On the roof of that facility that day was a roofing subcontractor and a mechanical subcontractor. Like most construction projects, but particularly that one, only the people that were working and needed to be working on the job were allowed on the job that day. Because of the pandemic, that particular owner did want to limit person-to-person communication correspondence. The roofing subcontractor had an obligation to inform the general contractor that he could not perform the job itself. He failed to do that. So he subbed it out to another subcontractor who failed to inform the roofing subcontractor that they couldn't man the job. So they go to a staffing agency in Central Alabama to find experienced roofing labor. Can't find any in Alabama. They found some down in South Florida through a labor broker. So 3 experienced roofing laborers come from South Florida to work on this job. They work all morning, and through lunch, they're going to take a late lunch. Earlier in the day, they had been hoisting roofing material through a roof hatch that was left open for them to be able to hoist this material to the roof. They go take a late lunch. It's in rural Alabama. There's no restaurants nearby. The only place to eat is a little country gas station. It's got a hot bar. One of the 3 gentlemen, who was a big guy, he was 6'4" and about 350 pounds. He hands his 2 co-workers, who he's known for several years, a $20 bill and says, "Order me 6 wings and get me a Coke. Got something I have to take care of." We later found out he went around the corner to drink. Because they get back to the job site, 3 guys decide they're going to eat up on the roof. He proceeds to sit down on the covered roof hatch. The covered roof hatch was not covered according to OSHA standards. He fell 29 feet. He lived 3 months before he passed away due to complications from COVID and his injuries. Four and a half hours after he was life flighted to UAB, his blood alcohol content was 3 times the legal limit. He had no business being on the roof, but the other witnesses will tell you they didn't think he was drunk, but we were probably dealing with an experienced alcoholic. We also found out initially he had no family. He was in a coma for 2.5 months. One of the trial lawyers that you see on TV somehow managed to get him to sign a contract while he was in a coma, where they were going to file suit against a defense contractor, against a general contractor, against a roofing contractor, against a mechanical contractor, and against the various staffing companies. Initially, there was no demand. And initially, there was no family to be heard of. We later found out there was a daughter he never knew about. She did not want the money. To this day, she hasn't collected any money. There was no initial demand, and part of the reason for the initial demand, and we're going to get into this a little bit, is because everybody that's getting sued started fighting, which is exactly what they wanted. And then when each of the parties started fighting and it came to a crescendo, then they made their written demand of $43 million. It was DEFCON 1. You see, nuclear verdicts are not always decided by facts and common law, but by a combination of psychological and sociological factors that lead to an erosion of the tort system. We're going to talk about that a little bit today. The word DEFCON 1 was brought to our attention. Anybody who was born before around 1975 or earlier may remember the movie War Games. Anybody seen the movie War Games? Great movie. 1983, it had a budget of $12 million. It grossed 10 times that, $124.6 million. It was nominated for 3 Oscars. At the time, it seemed somewhat foreign. There was this really smart kind of antisocial kid who was very intelligent when it came to with computers. He was able to hack into his school system and change his grades. He manages to hack in to this gaming system that leads to the threat of World War III and nuclear annihilation. And that was when I heard the word DEFCON 1 for the first time. This DEFCON system was created in 1959 by JSOC, the Joint Chiefs of Staff, at the height of the Cold War, as a better way to gauge the danger level that we were in with the Soviet Union. DEFCON 1 has never been declared. DEFCON 2 has one time. You know what time that was? Yep, the Cuban Missile Crisis in the Bay of Pigs. DEFCON 3 has only been declared twice. You want to guess when? 9/11. The other one may shock you because it's so recent. January of 2023, the day Russia invaded Ukraine. They put us on DEFCON 3. At DEFCON 2, these are the military code names they use. Basically, the readiness type at DEFCON 2, the subs are at sea, they're activated, they are ready to fire. The bombers are on the runway with the jets running. DEFCON 3, all the troops are ready to go and ready to activate. DEFCON 4 and 5 is where typically we live. But DEFCON 1, it says nuclear war is imminent. And that's where we are with nuclear verdicts. So for the purposes of today's presentation, we're going to define nuclear verdict as any verdict in excess of $10 million. Thermo or thermal nuclear verdicts are any verdict in excess of $100 million. Unless I point out otherwise, the 2 sources we're going to use for today's presentation are going to come from the U.S. Chamber of Commerce. They got about a 45-page program they put together. They do a study about every 5 years on the tort system and how it affects business. They published this last year in 2024. It's on their website. And then this book, Nuclear Verdicts, it was written in 2020 by Robert Tyson Jr. Robert Tyson Jr. is a defense attorney that he speaks all over the country on this topic. He has been preaching this for 2 decades, and a lot of what I'm going to talk to you about today is pulled from these. Now, I'm going to mention a lot about nuclear verdicts. I'm not going to talk a whole lot about settlements. The reason why is there's no good source for settlements. Some states have good sources, but nationwide, we have no good source for settlements. It is estimated, this is good data, between 2013 and 2022, there were 1,288 nuclear verdicts. So verdicts greater than $10 million. It is estimated that the settlements in excess of 10 million were anywhere 5 to 10 times that in that same time period. So industry is actually more at risk of a settlement than a verdict, because typically when you have a high profile catastrophic case, very rarely do they actually go all the way through the court system. Half of those almost 1,300 nuclear verdicts, the verdicts came between $10 million and $20 million. 1/3 came between $20 million and $50 million. In 2022, there was a record number of mega or thermal nuclear verdicts, those in excess of $100,000. The median verdict in 2022, well, really for the whole time period, was $21 million. But in 2023, and this was released last December, and it was still green data, there were 129 nuclear verdicts alone. So about the same number on an annual basis the previous 10 years. But notice there were 27 greater than 100 million. And notice the difference from 2022. The median verdict going from 21 million to 44 million. The majority of the nuclear verdicts come from product liability, auto liability, medical liability. Now, product liability is the one we're all most familiar with. You want to take a guess what some of them are? Roundup's probably the most common one that's running the course now. Pelvic mesh implants were another big one. Talcum powder, tobacco, asbestos. Auto liability is probably the one that is entered into court more often than not now. But this is why all industry needs to be aware. Auto liability, only 1 out of every 4 cases that end up with a nuclear verdict involve a commercial trucking company. Only 1 out of every 4. And medical liability also. The 3 of those make up 2/3 of all nuclear verdicts. 1/3 of the verdicts include punitive damages. We aren't going to talk a whole lot about that because different states have different laws on punitive damages. AM Best, the international rating agency for insurance carriers, says the United States is at greatest risk of nuclear verdicts than any other country. You want to know why? Because we have more laws and rules than any other country. And when the more laws and rules you have, the more likely, whether it's intentionally or inadvertently, you are to break them. This is an interesting fact, but I don't think it's by coincidence. We're going to touch on this a little bit later. State courts are much more likely to issue nuclear verdicts than federal courts. 9 out of every 10 nuclear verdicts come out of the state courts. We have a chart here in a table, and it kind of shows you some very interesting data. So number one, the most expensive is what we would probably suspect. Product liability, the Roundup, the talcum powder. You see the mean was about $216 million. The median verdict was $25 million. It makes up 23.6% of the verdicts in the 10-year period, 2013 to 2022. Other negligence. So it's kind of hard to describe, but the best way I'm going to describe that to you is that is basically when a business is negligent for something other than a premises liability, a slip or fall. It may be hiring negligence. They hired somebody that might have been a loose cannon they weren't aware of, and that person has a mass shooting and they get sued. That's what other negligence is. It also has a high payout, almost 100 million with the median of 20 million. But notice it only makes up about 8% of the verdicts. Why do you think that's the case? Much harder to prove. Intentional torts, they're also very high. If you get found guilty, almost 95 million with a mean of almost 29 million, but it only makes up 7.1. Same story there. Very, very hard to prove, but if you can prove it, big payout. Auto accidents make up 23%. Medical liability make up 20.6. Premises liability, the slip and falls that happen at a facility or an office, make up 15%. The average or mean of almost 32.5 million. And then miscellaneous were various liability cases that did not fall. Basically, what those are cases where the state law does not allow them to tie it to one of these categories. If you wrap all of those 1,288 claims in that 10-year period, the mean paid out was almost 89 million and the median was 21 million. The top 10 states for nuclear verdicts. Alabama's not on there. We're going to talk about that in just a second. Any of these shock you? We have Tennessee, New York, Georgia, Virginia. I said Tennessee. Tennessee's not in the top 10. New York, Georgia, Virginia, Delaware, Louisiana, Pennsylvania, Missouri, California, Florida, and Texas. There are 4 up there with little asterisks. Those 4, New York, Georgia, Texas, and Florida, account for nearly half of the nuclear verdicts that occurred in the United States from 2013 to 2022. There's a map I probably should have added to this. It's another ranking now, or it's more of an outlook of nuclear verdicts by state, and different colors determine or show or reflect how much risk that businesses are in those states for nuclear verdicts. Alabama would be just outside of that top 10, so would Tennessee. In the last 2 years, legislation has been introduced in Georgia, in Louisiana, in Florida, and in Texas, and in Alabama. Really didn't get anywhere. For tort reform to reduce the risk of nuclear verdicts. In the state of Alabama, this was prepared by a group, Alabamians for Legislative Reform. It is estimated that lawsuit abuse in Alabama cost Alabama $7.3 billion in lost economic spending, $2.3 billion in lost personal income, and almost 35,000 lost jobs. So what is causing the rise in nuclear verdicts and the significant rise in the last 5 years? Number one, there's been a cultural shift to occur. And it's something that did not happen fast. It's happened over decades. If you look back to certain generations and how they were raised by parents and schools, there's no doubt there is a difference. We are taught that fair is fair and that there should not be bullies, particularly the younger generation. They don't always know that sometimes life is tough and it's not always fair. So the level of expectation of what someone deserves is a little bit different from the older generations. The big change has occurred at the judicial level. In Alabama, the average citizen, and very few citizens, and I myself was included up till a few years ago, know nothing about judicial candidates when they go to the election polls. All you know or all you see is Democrat or Republican. There's a group out there of trial lawyers, of plaintiff lawyers that really don't care if you're Democrat or Republican. They want their guy, their man or woman, in that judicial spot. And we know in Alabama, certain parts of the state tend to vote Democrat, certain parts tend to vote Republican. The other fact of the matter is typically judges get paid less to be a judge than practicing law. Some of the best lawyers that would make great judges don't go that route because of the pay disparity and because of the lack of appreciation, which has led to people getting elected, not because of their work, but because of the party that is listed behind their name, because nobody knows anything about them. And they get elected because they had money that was funneled from the trial lawyers to get them elected. Not going to name names, and I'm not going to name position, but there's someone on our Supreme Court, the largest donation received for that person came from the trial lawyers, and it was 5 times larger than any other political donation. Plaintiff bar strategy. We're going to talk in more detail about that. Litigation funding, social inflation, and the reptile or rhino theory. All this leads to an erosion of the tort system, which then leads to nuclear verdicts and settlements. So plaintiff bar strategy. The American Tort Reform Association put this out at the end of 2024. In 2023, $2.4 billion was spent in the United States for personal injury ads through 26 million channels. But this is the biggest difference between the certain segment of lawyers and defense lawyers. Most defense lawyers, most law firms are those traditional law firms that you see in picture. Most of the trial lawyers, plaintiff lawyers that practice in this space aren't traditional law firms. They're businesses who just happen to be lawyers. So it's out there, it's on public, so I don't mind sharing this with you. Alexander Shinar. I've known Alexander for a long time. I knew him before his name was Alexander. I've known his family really well. I know when he dreamed of being a lawyer, and I thought that will never happen. I watched all these big law firms say that guy is a joke, and they now look at him with the utmost respect. Business Alabama, when they first opened up their podcast, had their first podcast with Alexander Shinar. If you want to know what's going on in this space, listen to that podcast, because you'll see it's not about law. It's about business. He's a smart businessman, and he's a shrewd businessman, very good at what he does. And so you aren't dealing with people who felt like they were necessarily called to practice law. You're dealing with very smart business people who understand how to operate. They don't operate like traditional law firm. They know where to invest their money to get the cases in their direction. Part of their strategy is anchoring juries, and what that means is this. So that written demand that we got in October of 23 of $43 million, if that had actually gone to court, they would enter that demand into evidence so that jury gets that figure in their head, 43 million. And that's by design. Because in most instances, they're going to anchor with a much larger number, 3 or 4 times what they really want to get. Because they know most juries like, oh, that's a lot of money. So half of that is still a lot of money, but it's not as much as 43 million. That's why they anchor. Social inflation has a lot to do with that. How much is a bottom line Major League Baseball player making now? What is the minimum? NFL football player? Yes. When you look at numbers and those contracts and what certain CEOs of certain Fortune 500 companies are getting paid, $10 million doesn't seem like a whole lot. Networking. So the trial lawyer group does a great job. They have regional and national conferences all over the country. They're widely attended. They pass out sample business plans. They the exhibitors tend to be marketing companies. You know, a lot of these ads that you see on TV aren't ads just for them. They'll fly to a certain city and they'll have 30 law firms from around the country all doing the same ad. And they literally line these guys, men and women up one after the other, and they film it all in 4 hours and they got these ads. But December of 23, I was at a dinner at a nice restaurant with one of our reinsurers, and there's a private room. And I see a lot of these pain doctors that we work with to help manage pain for our injured workers. And I see them going to this back room. I'm like, who are they going back there to see? So I peek around the corner. Guess who's hosting their Christmas dinner? All the trial attorneys, Alabama Hammer, Alexander, Morgan & Morgan, Wettermark Keith, guys who really don't like each other every day, but like each other that night, all in the room, bringing these pain doctors, pain management doctors in. Litigation funding. This is something that was addressed. I mentioned that legislation was introduced in Georgia. It passed last week. It was Senate Bill 68. I'm convinced that passed because the governor got behind it. The governor pushed it. It limits litigation funding. It also limits liability. It also puts limitations on evidence that could be omitted, and it puts a limit on attorney fees. But this is a real deal, and it's not regulated at all. It will be in Georgia. In 2023, there was $15.2 billion invested in litigation funding. This is what litigation funding is. It is an investor or a group of investors that put money towards a case and giving it either to the plaintiff or its counsel for a share of the settlement or the award. It's not regulated. The estimated annual returns on third-party litigation funding is 20% in 2023. There weren't many investments you could make, financial investments you could make that could garner a 20% return. 2/3 of that investment was what they call portfolio litigation. That's where they say, okay, I'm going to put $1 million towards DUI cases. They basically put it in a pot, and legal counsel can apply for that funding to help hire forensic engineers, expert witnesses. By the way, this number in 2024 was just released a few weeks ago. That went up to $16.1 billion. The average investment per case was $8 million, which was $200,000 more than what it was in 2023. Burford Capital is a publicly traded company. It's one of the largest third-party litigation funders. It provided money to 94 of the 100 largest U.S. plaintiff firms. The reptile rhino theory is this. What would you do if we opened that door and a rhino came running through? What would you seek? Safety and shelter. For those that are scared of snakes, what would you do if we dropped a snake in front of you? You would seek safety and shelter. The reptile rhino theory operates like this. So there's a part of our brain that activates. When that happens, it's that flight or fight response. Plaintiff lawyers are taking classes to learn how to activate that brain for the jurors on each and every case, to seek sympathy for the defendant. I mean, for the claimant, and punish the defendant. They teach this at seminars all over the country. The goal and strategy on this is to try the company, not the case. They want the jury to focus on the company and not the case, not the facts or the law. Why industry is at risk? A lot of this, I'm going to run through this because you guys know this. This is why you do what you do. Anybody that does a job outside of sitting at a desk is doing something that is inherently risky. It comes with liability. You hop in a car, it is risky. It comes with inherent liability. But what we struggle with contractors, and what manufacturers struggle, what chemical producers struggle with, the energy sector, is we tend to promote ourselves. With contractors, we tend to be wearing logoed PPE. We have job trailers with our logo all over it. We have wraps that go around a fence promoting our company. We have these huge equipment or auto fleets that have our logo on it. Not much different in manufacturing, transportation, chemical, or the energy industries, the paper industries. We like to brag about ourselves. And I don't care whether it's construction or what industry you're in, you're relying and having to utilize multiple parties, service providers, vendors, subcontractors, contractors, employees to get the work done. The larger that net gets, the more at risk of something happening. And in today's environment, most companies tend to have large working capital and reserves, with large insurance limits that are often stackable when multiple parties are involved. And in construction, that's a huge issue, because often insurance limits are required by contract and it flows down. And if you started stacking those limits, you want to know how Shannara got to $43 million? He looked at the bonding capacity. He found out the bonding capacity of the three primary contractors. And once he found that out, he can figure out about how much operating cash they have on hand. And then he looked at their insurance limits. If you combine those, came to $43 million. When all the other parties figured that out, they had an oh my gosh moment, because they're talking about real money, not some abstract number that everybody knows they can get to. If they are successful, they could get to all of it. That's how he came up with that 43 number. It wasn't just some abstract number he threw out there. He had done his homework. And a lot of that was provided through insurance. NVAs right now are the most frequent, I'll tell you this, the most frequent occupational fatality right now, according to the U.S. Bureau of Labor Statistics. Agriculture, construction, manufacturing, transportation, and warehousing are at the highest risk of catastrophic occupational injuries and fatalities in all other industries in 2023. Commercial umbrella liability limits for industry has been reduced by 40 to 60% in the last 10 years. What I mean by that is this. It is not uncommon in construction for a contractor to be required to carry a limit of $10 million of liability insurance. Contractors' ability to get $10 million has been reduced and reduced greatly. There were a lot of companies going back 7 to 10 years ago, had no problem getting a commercial umbrella policy for 25 million. That 25 million now is hard to get from one insurance company. That has dropped to 10. For those that needed 10 million, it is hard for them to get all $10 million worth of coverage with one insurance company. So they have to get it with multiple, and that is a problem. And you know why that is a problem? Have you ever dealt with an insurance company during a claim? If you're dealing with one, it's bad enough. You deal with more than one, extremely difficult. Cost for industry, it reduces our working capital, it reduces our insurance of capacity. Can you put a price on reputational harm? Then indirect cost, time and resources. The owner of that general contractor had over 300 emails on that case each month. Altogether, our defense team had over 10,000 emails. And you know, lawyers charge when they review an email every time on the clock. So it's not cheap. How can we prepare before the claim? In today's legal environment, if you have anything to do with protecting a company, the best advice I can give you is to look at all available resources. Where the pots of money are, where we're going to get it, and how much we have. How much do we have in reserve, in cash, and in investments? How much do we have from the insurance company? If you're not comfortable with whatever that amount is, you got to increase one or the other. The easiest way to do it is through insurance. But there are other ways to protect you that aren't as costly. Number one, and this, if no one has had any of their contracts reviewed in the last 12 months, it would be well worth having that contract reviewed and rewritten, because a lot of things have changed in the last 2 years. Know all of your partners, know all of your subs, just don't know who they are, know where they're getting their labor, how they're getting their labor, the quality of their labor, who they get their materials from. Find out their financial strength. If they really want to work with you, they'll provide it. And also their insurance. Hiring and training procedures is where it all starts and stops. A lot of times people hire a nuclear verdict. And goes without saying about the safety and the QA, QC programs, but that's not a one and done, as you all know. That's a part of culture. And if it's not a part of your culture, I don't care. You might as well just take that out, because it is no good and it'll do nothing to prevent a nuclear verdict or settlement from happening. Invest in technology and security. So there are a couple things I want to say on this. Nationwide insurance company turns 100 years next year, 100 years old. Started out as Farm Bureau Mutual, based out of Columbus, Ohio. They just did a survey of all of their commercial insurance policies. And this blew my mind, and it gives me hope for the future. 84% of their commercial insurance clients use dash cameras. If you'd have done that survey 2 years ago, it probably would have been the other way around. 84% did not use. What's driving that is this legal environment and nuclear verdicts. One of our largest companies we insure is a building material supplier. They also have a ready mix company. We looked at that company for several years. You could not do the math to make it work. Their losses, there was no way, unless they put serious skin in the game, that their losses were not going to outrun their premiums pay. And this guy is a nice guy, very active member, and he kept coming. I kept telling him, you don't know how badly I want to help you. But I knew until he was going to commit, nothing's going to change with that company. There were several things I told him he needed to do. In regards to the safety program, the other thing I told him, I said, you want to show your commitment, do telematics. He installed telematics, dash cams, the whole computer software where he can go back and look. He said, you know, my guys hated it at first, but he said, we were involved in an accident where our guy was not at fault, but we had witnesses who said he was. We were able to use those telematics to show that he was not. Saved my company a lot of money, and it saved my employee from getting fired. My people are behind it now. I just wish I'd have done this sooner. There's no telling how much me or my insurance companies paid out over the years I did not otherwise have to pay out. So telematics, wonderful. The other thing that's out there now is there's new AI that will help identify emerging risk within your company. New one that's just come out, it's called Predicat. That's Praedicat. It is a liability emerging risk analytic company. If you're a big corporation or a big entity, that is well worth the investment. It is going to catch things that maybe the human eye does not. Number 8 is one we don't talk about enough. Industry needs to be involved and invest in the community and promote. Why? Image, because when something bad happens, they're going to immediately think back, what do they know about you? If they don't know anything about you, they're going to believe what the other side is saying a whole lot easier than if you've already built this image that you're engaged in the community, you're working to make your community better. It helps fight all the bad things, and some of them may not be true, the other party saying about you. And then this is worth every penny, a crisis communication plan. We brought a guy in about a month ago to work with our members. We're bringing them back in October. We'll make it available for you all. One of the best in the business in developing a crisis communication and management plan. Communicate with claimants. Most people file suit because they get frustrated with the process. They are aggravated because they are left out of the loop. Whose fault is that? It's not the injured person's fault. It's us, the insurance company. It's us, the employer. If we don't communicate with the person, the odds of a lawsuit go up tremendously. If we don't provide an empathetic and experienced claims adjuster that takes genuine interest in that person, the odds go up drastically. The other thing that we do every time we have an accident occur is we're going to evaluate and assess the claim. We're going to investigate the claim first and foremost, gather all the facts, statements, interviews. If there's cameras, we're going to get all the footage, telematics tests. We're going to report it to insurance company, and we're going to assess for nuclear risk. And this is how we assess. If it's in the green, we monitor it, but we really don't discuss it. That's a single party incident with no bodily injury, no property damage, no legal representation. A yellow involves more than one party with bodily injury and property damage, maybe some lost time injury, maybe some property damage, short-term loss of income. We're going to monitor that. But those that involve multiple parties involving fatality, permanent or total, some type of catastrophic injury, it may handicap or disable an individual, catastrophic property damage, significant loss of income, that is DEFCON 1. And when it's DEFCON 1, the first thing to do is you go out to your crisis management plan, you assemble the defense team internally and externally. Even if you have in-house counsel, almost always recommend adding to your legal team an expert on that particular case. Forensic engineers are oftentimes well worth the investment. Jury consultants and lawyers. Evaluate the legal landscape. Look at all the lawyers representing all of the parties. If there's more than one party, get everybody in the room early and often to make sure every party understands the reality of the situation. And if you're guilty, admit it. Don't hide it, because the truth will come out. And if you hide it, going back to the rhino and reptile theory, they're going to hammer you when it comes to the verdict. This may be, perhaps it's kind of tied to that, the most important one. Determine exactly what the claimant wants. Is it money or is it an apology? Because either one of those two is going to direct how you defend it. Because if it's money, you're going to be in a fight. There are people, claimants, again, going back to, they sue because they're frustrated. All they really want is an apology. Large general contractor we have a member with. Their in-house counsel gave a presentation in this room 3 months ago. They had an employee who was killed in a trench. It was an employee he personally knew. He had known, they both started about the same time. This in-house counsel was hired when he was under 30 years old. He could not believe this person gave him a job. And he was only given one order from the day he was hired. He said, all I'm going to ask you to do is do what is right. This guy was hired with a trench collapse. There were several things this guy did not do and do properly. But this lawyer knew him and knew him well, knew he was a good person. They'd hired jury consultants. They had, their legal team had advised him to do this and that. They were going to hit on this guy pretty hard. They get to trial, and this employee's wife was there. And they're prepared to slander this guy, to talk him down, make him look bad, make it look like it was his fault. And he said, as I looked into his widow's eyes, the first order I was given by the guy who hired me, do what is right. And I thought, by golly, I may get fired, but I'm going to do what is right. I looked that widow in the eye and I said, there's no amount of money I can give you that's going to replace what you lost. I am sorry. We are sorry. Should have never happened. She asked to see him outside. And she was crying. She said, that's all I ever wanted to hear. She withdrew the case. That company ended up giving her a sum of money for her loss in addition to what they had already paid out. But oftentimes, if it's about an apology, there's no need to go the legal route. Legal route's very expensive. Be proactive. Don't let the claim sit still. The longer you let a claim in today's legal environment matriculate, the worse it's going to be. The numbers go up by the month. Be ready to adapt and pivot strategies. We talked about communicating. Do not be afraid to pursue alternative dispute resolutions. Look for the best alternative to negotiated settlement through arbitration and mediation. All right. So we had that case with a written demand of $43 million. We don't give them $43 million. One subcontractor's wanting to sue another subcontractor. The general contractor just wants the two subcontractors to identify and hold them harmless and defend them like they agreed to. Every side was fighting. 2 weeks before they're supposed to go to trial, one of the attorneys working for Shinar had just won an $18 million verdict. Strike one. Defense lawyers, insurance lawyers start getting worried. 2 days later, the judge issues a ruling, and I have theories about this, but the judge issues a ruling that he was not going to allow the blood alcohol sample to be entered into evidence. Strike two. You had almost $26 million of insurance money available. The big players that really start circling are the umbrella carriers, who aren't necessarily the same insurance company as the underlying. They won out because they've got $10 million on the hook. So look, if we can get out for a whole lot less, let's get out. We wanted to fight the case. Guy had no business being on the roof drunk. But at the end of the day, felt like the facts would back us up. At the end of the day, Shinar floated out there that they might be willing to walk away with a settlement. It settled in excess of $10 million. We had to give up our $1 million. Our general contractors, umbrella carrier gave up $1 million. The subs took on the rest. It was an accident that should never have happened. And there's no amount of money to make up for a man losing his life. But given the facts of the case, it was not a $10.3 million case. I honestly believe that case could have and should have settled 2 years prior for somewhere between 1 to 3 million. Guess where that money is sitting right now? In a trust, where it'll sit for a certain period of time. And if it's not collected by a family member, it will be designated to go to a 501c3 nonprofit. But guess who got 40% of that money? The team that is so strategic, that is causing these things to happen. So thank you all. If there's anything we can ever do for you all, please let us know. But it's been an honor to speak to you today.
Any questions? Yeah, you got that.
Two comments.
Yes.
It's, I've been involved in probably 20 depositions, the crane company and all that. The first thing is, insurance company has lawyers. Guy suing has lawyers. They drag this thing out forever and ever and ever, and then somebody says, we gotta take this to court, we got a good case, we're gonna win. And about a week, 2 weeks before they settle. So the lawyers make money, and the frustration and what it does for the morale of management and what allows other people to do. The other thing I had a problem with is he tried to help. We had a gentleman who almost lost his arm, and for the first 7 days he was at UAB. So I went every day. They transferred him. He spent 5 days in Memphis. I went up there and spent 5 days with the family. As soon as it got wind that they've been in touch with lawyers, I couldn't talk to them. Guess what? The insurance people don't have anyone that's really in public relations either.
Right.
And they don't talk to them. And now the family is really upset because it was important, but where were you now, Danny? Where am I now?
Yeah.
You know, and there's nothing I can do, and it's just frustrating in safety. And sometimes the insurance people, there are some great insurance companies. There are some people that work for them that ain't worth a shit.
Totally agree 100% with you, Danny, on both accounts. So the example I gave you with the large general contractor, almost the same exact thing happened. The insurance company told him, you can't talk. His defense counsel told him, You can't talk. You would be in violation. At the end of the day, he didn't care. And, I keep going back to the number one reason why people typically file suit is because they're aggravated with the process. They want to know you care. I will say this, having even been on both sides, totally agree to you. It wasn't until I observed this as I try to keep myself as an independent third party watching this one case. 100% correct. Lawyers are going to do what they're trained to do and what they make money doing. Insurance companies think they're the smartest companies in the world. And they each think only they know how to resolve those claims. Industry, any business, I would urge them to do this. Have your own resolution team and don't necessarily, you make up your mind what you're willing to do and not to do before, just like the crisis management plan, developing it beforehand, develop a crisis resolution team and plan what you're going to do when something happens, because yes, these lawyers and the insurance companies will tell you things not to do that are counterproductive to the outcome.
Oregon and Alabama got 2 years to file a law.
You do.
And you will see with certain companies, they try to slow walk it because they will get you past that 2-year period. Like you're not going to be able to file a suit at that point in time. At that point you can't, but at that point, they think if I can wait this, I've got all the leverage of that. And you see that with a lot of, shall we say, smaller cases that add.
Yes.
But you see that with insurance companies, you see that with, the attorneys they got on staff.
Well, you guys, you have it the worst because you're on the front lines. You're the insulation between both parties. And when something bad happens, you're the one that's usually thrown in the middle. And so we recognize what you do, how you do it, and why you do it, and we appreciate what you do.
Thank you, Jeff.
Thank you.
Don't leave, Jeff, hold it. Hold it. We'd like to give you the coveted
Oh,
ASSP coffee mug,
thank you so
Which
much.
is-
I will covet that.
which is both microwave and dishwasher safe, I hope.
Well, thank you. Well, thank you. Thank you so much.
Thank you very much. Enjoyed it. Get yourself some lunch and I'll go with my part of it.
Oh, yeah, how about it? Yeah, but we also got, gas and.
I'm gonna get going on my presentation here and talk about a few things and so forth, so I can get you all out of here before rush hour traffic on Friday afternoon. Any new members, any new guests that showed up? We do have Premier Tech safety person here. You want to introduce yourself?
On the health and safety advisor for Tech. We are a manufacturing facility that does Peloton, babies and robots. We have a new one called so the home board industrial, and it's so easy of
And you made it all the way up from Montgomery, so thank you for making it all the way up here. Any announcements? Anybody have any announcements at all?
All right, 7 o'clock. In Pittsburgh, Pennsylvania, my grandson will be racing Supercross there. He'll be on TV on Peacock at 7:05. And this is his 5th, what they call Supercross Next Series. These are 5 races, but about 22 people have been invited to join the next year's pros. And he's 18 years old, and so we're excited that he did well, and he went to Arizona and Daytona, Birmingham, Boston was a mud fest, and now Pittsburgh's supposed to win too. So anyway,
What is motocross? So it's all on dirt, so it'll all be muddy, right? Or are some of them on asphalt? Yeah.
Skid steer, get some motorcycles out of the mud.
Oh.
So
Um,
it's sad about this.
Any safety shares or issues, Anybody want to talk about? So training opportunities coming up. You can check University of Alabama's Safe Day program as an OTI group, and they have courses every month. I picked a couple coming up in May: hazardous materials and fall protection. One's going to be virtual, one's going to be at the BCC over at the university. And they have a lot more classes. You can check at their website here. For the Deep South Center for Occupational, Deep South Center UAB. I don't know what's going on there. None of the classes you can see are available. There's a contact person's name on a piece of paper taped over all their schedule. So something's going on. I don't know if they have to redo the schedule and so forth, but you got to contact their contact there to figure out what classes they're holding over the next few months. Some of the conferences coming up, or some of the events coming up is the National Safety Stand Down, which is May 5th through 9th. OSHA website has a ladders and falls video that'll be available to see. Are we gonna do something at the University Safe State for fall stand down? Matt? Okay. Obviously, Safety 2025 is gonna be down in Orlando at the conference center down there from July 22nd through the 24th. There'll be pre and post conference classes going on. And then obviously the Governor's Safety and Health Conference is coming up August 25th through 27th. Again, there'll be pre-conference courses on Friday and Saturday before the conference. Chapter meetings coming up. May 16th is our long-term member recognition luncheon. We're also going to celebrate Tina Arthur Peterworth. She's our safety professional of the year. And we're going to also honor Frank Lakatich with our Lifetime Service Award at this event. It'll be May 16th. Again, we will have a nice lunch along with Cheesecake Factory cheesecake, which I hope you will eat this year because I had enough cheesecake for 6 months after the event. After the recognition luncheon, we will have a executive committee meeting to finalize the comp, which we've got to send in. May 23rd, Tuscaloosa, West Alabama section will be having their next meeting. It's at the Innovation and Discovery Center, the Gateway Center over in Tuscaloosa. 11:30 start time roughly. The presentation will be to be determined. And then on June 20th, we'll have the final 2023 through 2025 current executive committee send off for the new executive committee that's coming on. And for those of you who went through my painful video work last month when I killed everything, we issued a slate, and this is the slate from last month that was issued. This is the current people who are going to stay on or come on as our Vice President Braxton McCallum. And if any member is still interested in becoming one of these, there's a nomination form you can fill out, as well as 15 members' signatures to support your candidacy. And that's it. May 16th, our next meeting, and we'll see you then. Enjoy your lunch. Thanks for everybody who attended by Zoom.